and they were not deceived by that. But notwithstanding that,
The Honorable, the Chief Justice and the Associate Justices of the Supreme Court of the United States. Oyez, oyez, oyez. All persons having business before the Honorable, the Supreme Court of the United States, are admonished to give their attention, for the Court is now sitting. God save the United States and this Honorable Court.
We will hear argument first this morning in Case 19-1231, Federal Communications Commission versus Prometheus Radio Project, and the consolidated case. Mr. Stewart.
Mr. Chief Justice, and may it please the Court, Section 202H of the Telecommunications Act of 1996 reflects Congress's conclusion that, in light of intervening competitive developments, broadcast cross-ownership restrictions adopted in an earlier era may no longer be warranted. To ensure that such restrictions do not remain in force simply through inertia, Congress required the FCC to re-examine those rules every 4 years and to repeal or modify any rules that no longer serve the public interest. After reconsidering its ownership rules in accordance with Section 202H's mandate, the FCC determined in 2017 that its newspaper broadcast and radio television rules should be repealed entirely and that its local television rules should be relaxed. The Commission explained that the profusion of new media outlets, particularly through cable and the Internet, alleviated the viewpoint diversity concerns that had originally justified the restrictions. It further found that the rules disserved the public interest by preventing economically efficient combinations that would provide consumers better broadcast service. The Court of Appeals did not find fault with that analysis. Indeed, the Court in 2004 had sustained the FCC's determination that the blanket newspaper broadcast cross-ownership ban no longer served the public interest. The Court nevertheless vacated the FCC's rule changes on the ground that the agency had not adequately assessed the changes' likely effect on minority and female ownership levels. The Court's elevation of that single factor has no basis in the governing statute, and the Court failed to show adequate respect for the agency's predictive judgments and its balancing of competing policy objectives. The Third Circuit's judgment should be reversed.
Mr. Stewart, was the FCC required to consider the impact on minority and female ownership in the 2017 reconsideration order?
We don't think anything in the statute required the FCC to consider that factor. The Court of Appeals, in what we refer to as Prometheus 3, its prior decision in this line of cases, had included a footnote that directed the FCC, when it next reevaluated its cross-ownership rules, to consider that factor. And the analysis that the FCC did in the reconsideration order was in compliance with the Court's mandate. But we don't. So
it could have said nothing about that at all in changing the focus of its regulations?
Yes, historically, when the Commission has adopted cross-ownership rules of various sorts, it has been to promote viewpoint diversity and localism, to ensure that there is as much of a plethora as possible of distinct voices within the local community. And it has not historically taken into account impacts on minority and female ownership in conducting that analysis. And nothing in 202H would have required the Commission to start doing that in its quadrennial reviews.
What scrutiny would apply when the Commission simply shifts priorities? Let's say that there was consideration of female and minority ownership and the cross-ownership rules, and it just decided, well, we think the latter is more important than the former, so we're going to focus solely on the latter.
I think it's really rational basis review. That is, if the FCC had decided to adopt an explicitly race or gender-conscious standard, that is, give a preference to members of racial minorities or to women as such, then it would be required to satisfy heightened scrutiny. But
thank you, Counsel. Justice Thomas?
Thank you, Mr. Chief Justice. Mr. Stewart, you indicate that the landscape in the area of viewpoint diversity has changed over the years. Could you talk a bit about that, particularly? I'm interested particularly in the effect mentioned in your briefs and some of the others as a result of some of the new Internet-based platforms.
I think the idea is that when the rules were first adopted, in many local communities there might be 3 broadcast stations and 1 local newspaper, and basically 4 independent voices within the community providing local news coverage and other forms of coverage. And if 2 of those outlets were owned by the same entity, that would be a substantial diminution in potential viewpoint diversity. Now, when you have a plethora of internet-based platforms, cable stations that can also provide local news coverage, the reduction in viewpoints within the broadcast sphere specifically is not going to be nearly so significant in light of the profusion of different viewpoints that will be available to the consumer.
So do you have, is there any sort of structural program or requirement that would, such as we have here, that is specific to these alternative platforms?
We really are not talking in this case about regulation of the internet or regulation of cable. I think the justification for enhanced regulation of the broadcast media has always been that the broadcast spectrum is scarce. Not as many people can broadcast on the frequencies as would like to, and therefore it's necessary to have a federal agency that allocates the spectrum and decides how it can best be used to serve the public interest. And there isn't the same sort of need with respect to cable and the internet because one person's voice doesn't crowd out another's.
Thank you.
Justice Breyer.
I'm thinking of it solely as the anti-merger part. In anti-merger law, merger law generally, I think, has a theory, and the theory is beyond a certain point and other things being equal, you have fewer companies in a market, the harder it is to enter, and it's particularly harder for smaller firms. And here, smaller firms are heavily correlated, or more likely to be correlated, with women and minorities. Or the opposite view, which is what the FCC has now chosen, is they want to move or allow to be moved towards more concentration. So what's the theory? That wouldn't hurt the minorities and women or smaller businesses. What's the theory the opposite way, in other words? I'm not asking for data. I'm asking for a theory.
Well, let me take the 2 points you made in order. The first is with respect to possible advantages to small entities. The FCC has devised other programs like the incubator program and the eligible entity definition that are intended to give certain regulatory advantages to small entities. And those rules may incidentally benefit female and minority owners or prospective owners, even though they're not limited to those people. The second thing is the theory behind what the FCC did was, in part, the data don't show it, but in part, with respect to some of these rules, the intuition really isn't there once you unpack things. For example, with respect to the newspaper broadcast cross-ownership rule, the rule that a single entity can't own both a newspaper and a broadcast station. The FCC found that if that rule was eliminated, the most likely consequence is that broadcast stations would buy newspapers rather than the reverse, because
Mr. Stewart, you said earlier that the Commission was not required by the statute to consider minority and female ownership, but the Commission did that, and therefore, could we reverse the Court of Appeals on the ground that the Commission simply wasn't required to consider this factor at all? And does it matter that the panel had previously indicated that the Commission had to consider that factor?
I think if you concluded that the statute actually barred the Commission from considering that factor, you could reverse the Court of Appeals on that basis. I think if you simply concluded that the Commission was either allowed to do it or not as it chose, you might think that you need to analyze the Commission's assessment of that factor at least a little bit in light of the fact that the Commission analyzed it. But even the Court of Appeals didn't say that the Commission ignored the weight of the data or that the data affirmatively demonstrated that female and minority ownership levels would be reduced. It simply said the Commission hasn't amassed enough data to reach an informed conclusion one way or the other, and we think that was certainly error.
On that point, the Court clarified in Fox Television that the APA doesn't require, quote, obtaining the unobtainable when it comes to data supporting a decision, but that the agency might be required to analyze data that, quote, can be readily obtained. There's a big gap between those two poles. Where should we draw the line?
I think here it's not a matter of the data could readily be obtained. That is, the deficiencies in the data don't result from the agency's current data collection practices. What the agency was trying to do was assess the potential consequences of relaxing the ownership rules by looking at arguably analogous regulatory changes that had occurred in 1996 and 1999 and asking what happened after that. And so the deficiencies in the data are really deficiencies in the data that predated those regulatory changes.
Justice Sotomayor?
Mr. Stewart, I'm a bit confused. It seems to me that the FCC for decades has been saying that minority and women ownership is a consideration of it is in the public interest. And I don't see anything in the ruling below that was subject to review by the circuit that said otherwise. It may have said that it didn't think the changes would affect that issue. It said other things, but I don't think the FCC has ever disavowed that consideration of that factor should be given in its review.
The agency has frequently said that this is a factor that may be taken into account in its public interest analysis generally.
All right, then let's stop there. That's exactly what it said, and I saw the circuit court saying that's what you said, but your consideration was inadequate because you didn't explain it. And we have a legion of adequately explain it. We have a legion of cases that say you don't have to rule in favor of one point of view or another, but when you're rejecting something, you should give it adequate consideration. Isn't that what we're judging?
I think there are two things I would say about that. The first is that although the agency has historically looked at enhanced female and minority ownership as a goal to be achieved through some means, it has not historically looked at that criterion as a basis for its cross-ownership restrictions. In adopting those restrictions, it's looked at other factors. The second thing is that the Court of Appeals chided the agency not for conducting an inadequate analysis of the data that were available, but for having inadequate data. And I think we've made a strong showing that there were no better data available with respect to the demographic composition of the ownership group pre-1996, pre-1999.
Thank you, counsel.
Justice Kagan.
Mr. Stewart, if I could continue in that vein, as I understand it now, you're saying that female and minority ownership has not really been a factor in 202H determinations, but it's not the way I read your brief, and I think it's not the way I read past actions by the FCC under 202H. So I'm wondering, what are you saying here? Are you saying that this is a new thing, that those things are not considered, or that they've never been considered under 202H, which is not what your brief says? What are you saying?
I mean, what I was really talking about was the era well before Section 202H was enacted in 1996, the era back in 1975, for instance, when the Commission first adopted the newspaper broadcast cross-ownership ban, and the years since then when it had retained that ban and when it had adopted rules dealing with radio and television cross-ownership. In that era, the rules were justified by considerations of viewpoint diversity, but what the Commission meant was it's better to have more independent outlets in the community rather than...
I'm still not really understanding you, Mr. Stewart, so I'll just ask, in your brief you say the agency has traditionally treated this form of broadcast diversity, meaning minority and female ownership, as an element in its multi-factor public interest analysis. Are you still sticking to that statement?
It has often said that, and it has tried to devise ways that that objective may be achieved other than the cross-ownership rules. So, for instance, with the eligible...
if you look at this, in this rulemaking, were you saying, look, we don't think that the changes in these rules will affect female and minority ownership? Or were you saying something more like, we don't have evidence of this, and we're not going to let speculative arguments get in the way of what we want to do otherwise?
We were saying the evidence is fragmentary, but based on the evidence we have, our best assessment is there will not be a substantial effect. And the mere possibility that there could be such an effect is not a sufficient basis for foregoing regulatory changes that we would otherwise deem to be very desirable. But
Justice Gorsuch?
Morning, Mr. Stewart. The parties dispute the propriety of the Third Circuit holding on to this case and all of its various iterations for the last, 17 or so years. I'm curious what the government's position on that is.
In succeeding stages of this litigation, there have been petitions for review filed in other circuits, and there have then been requests to transfer the cases to the Third Circuit. The government in the past has not opposed those requests. I think we're a little skeptical that the Third Circuit's repeated statements that it is retaining jurisdiction really have operative legal effect. That is, if the next time around a petition for review is filed in some other circuit that would otherwise be an appropriate venue, that circuit can decide for itself whether to transfer the case to the Third Circuit, but we don't think that that circuit would be under an obligation to do so simply because the Third Circuit has included this language about retaining jurisdiction in its prior order.
Thank you.
Justice Kavanaugh?
Thank you, and good morning, Mr. Stewart. Follow up on Justice Sotomayor and Justice Kagan, make sure I'm clear. Under the statute and the public interest standard, does the FCC have to consider the effect of relaxing the rules on women and minority ownership?
No, we don't believe so. The fact that it is a public interest consideration that could be taken into account in making other sorts of decisions doesn't mean that we have to consider it in making every single regulatory decision we make, including relaxation of the cross-ownership rules.
Do you agree that the FCC did consider it here?
It considered it, and if the FCC had concluded there was likely to be an adverse impact on female and minority ownership, it would then have had to decide how do we balance that against the identified benefits of the rule. The FCC never got to that point.
Having considered it, doesn't the FCC have to justify how it considered it?
I think the very most you could say that the FCC has to do is provide a reasonable, not necessarily a view that the court deems correct, but a reasonable view of the evidence that is before it. It doesn't have to amass additional evidence simply to be able to pronounce with a higher degree of confidence.
And follow up on Justice Breyer's question, what's the theory for why it wouldn't hurt women and minority ownership? The theory he asked, can you continue your answer there?
Yes, with respect to newspaper broadcast cross-ownership, for instance, the Commission found that the most likely consequence of eliminating the ban is that broadcast stations will buy newspapers rather than the reverse because the newspaper industry is in such trouble. And if a broadcast station buys a newspaper, that doesn't affect any form of centralization or consolidation of ownership within the broadcast industry. The existing broadcast owners remain the same. It's just one of them has bought a newspaper, and that may allow it to achieve economies of scale and provide better service to the community.
Thank you.
Justice Barrett?
Mr. Stewart, I want to go back to the questions that Justices Sotomayor and Kagan were asking you. I understood your brief to be saying that the FCC, or to be conceding that the FCC had long taken minority and women ownership into account. But then you pivoted a little bit and said that it took into account because the Third Circuit's opinion required it to. I wasn't entirely clear which position you had settled on, so could you clarify that for me?
I think what I meant to say was it has long identified minority and female ownership, an increase in ownership levels or a decrease in the current underrepresentation as a good that would serve the public interest. It has not historically taken that particular public interest factor into account in determining whether particular cross-ownership restrictions specifically should be adopted or retained. For for example, it attempts to achieve that goal through other means, such as preferences through small businesses that are race and gender neutral, but may incidentally help minority and female owners.
Mr. Stewart, can I just interrupt and ask another question before my time elapses? Do you see a difference between a stated goal of enhancing minority and female ownership and not harming minority and female ownership? And if so, which is the FCC's?
I think it is both. I think the FCC would be cognizant of either argument, again, outside the cross-ownership context, either of arguments that an existing regulatory change is good because it will increase minority and female ownership levels, or a proposed regulatory change is bad because it would decrease them. I think the FCC would be open to either form of argument. And again, what we're talking about is race and sex neutral measures, not race or sex preferences.
Thank you, counsel.
A minute to wrap up, Mr. Stewart.
Thank you, Mr. Chief Justice. I think it's easy to lose sight of what extensive analysis the FCC did here, because so much of that analysis is undisputed. The FCC concluded that because a variety of alternative media voices are now available to consumers, the viewpoint diversity concerns that originally prompted the cross-ownership rules were far less acute today. The FCC also explained that if the ownership restrictions were repealed or relaxed, owners could achieve economies of scale. For instance, a broadcast station, by buying a local newspaper, could use resources with respect to the gathering and the dissemination of local news on both platforms, and it could thereby provide better broadcast service to its consumers by using the resources of the newspaper. Thank you, Mr. Chief Justice.
Thank you, counsel. Ms. Walker.
Thank you, Mr. Chief Justice. May it please the court. In this case, the FCC decided that broadcasters should not have to operate under ownership restrictions dating back to the Roosevelt administration. I'd like to focus on the statutory reasons why that was lawful. 202H was meant to drive real reform with a focus on competition. Here, the Commission's statutorily required findings that the rules are no longer in the public interest as a result of competition are unchallenged. Yet the Third Circuit vacated the order because the Commission failed to adequately consider minority and female ownership. The statute does not say one word about that issue, and the APA does not require the FCC to consider it either. The Third Circuit had no basis, other than its own policy preferences, to make that a mandatory, much less controlling factor in all 202H reviews. The FCC properly did the job Congress gave it. That is what matters, and the order can and should be upheld on that ground. I welcome the court's questions.
Ms. Walker, are you saying that it would have been arbitrary and capricious for the Commission to consider the impact on minority and female ownership?
No, but it was not required, as you asked, Mr. Stewart, Mr. Chief Justice. And in fact, under the Commission's analysis of the order, the outcome of the minority and female ownership discussion couldn't have changed the outcome, because the FCC decided, for instance, that the newspaper broadcast cross-ownership rule was no longer in the public interest and had to be repealed before it even got to the minority and female ownership discussion.
Well, given that the Commission had considered minority and female ownership for some time, wasn't it under some obligation under State Farm, for example, to explain why it was not focusing or even weighing that interest in the 2017 order?
No, Your Honor, because the Commission never relied on minority and female ownership as a basis for the structural ownership rules, which are the subject of 202H and what this entire case is about. The Commission has alluded to that as a policy, but never in the context of these rules. In fact, it has said the opposite, that these rules are an inappropriate vehicle because they don't really work to promote minority and female ownership. It said that in the 2014 review, in the 1985 order, and in the order on review here.
To what extent, if any, does your position is your position inconsistent with the Solicitor General's position?
On the question of what the Commission has historically done, not inconsistent. We're just being more specific to say that policy has never been advanced with respect to the ownership limits, and I heard Mr. Stewart say this morning that he agrees with that. We would like the court to resolve this case on statutory grounds and not merely decide that the Commission's consideration of the minority and female ownership issue was adequate.
Justice Thomas?
Thank you, Mr. Chief Justice. Ms. Walker, to follow up on your last answer, can you think of any example of an instance in which the FCC has used structural ownership rules such as this one to advance minority or female ownership?
I do not believe, after my extensive work on this case, that there is a single example of that. And again, the Commission has said the exact opposite. It has said that structural ownership limits are not an appropriate means to promote minority and female ownership because there is no evidence or any demonstrable indicia that those rules actually promote those interests. The Commission has therefore chosen direct means, Justice Thomas, like tax certificates and distress sales. That's how the Commission has promoted those interests. And it just has never done that ever with respect to the structural ownership limits, and that is what this case is about.
So what do you think, other than diversity of viewpoint, what other interests are being advanced by this rule?
The traditional public interest rationales for these rules, Your Honor, are viewpoint diversity, localism, and competition. Those three rationales underlay the adoption of the rule, and the Commission has consistently relied on those. We think those are appropriate factors. But on our proffered reading of the public interest in this statute, we don't think the Commission or commenters can draw in brand new rationales as an excuse to keep outdated rules, or worse, to make more rules. That turns the statute completely upside down.
So have these interests become somewhat less important with the rise of other platforms, particularly the Internet platforms?
Yes, Your Honor, and I think your question draws out the fact that the broadcasters' competitors, all these new platforms, all these new social media formats are completely unregulated, yet broadcasters labor under these rules that literally go back to the 1940s. That makes no sense and is extremely unfair as a competitive matter, which is why the Commission reasonably decided to free broadcasters of these archaic rules.
Justice Breyer?
Thank you. I'm going to oversimplify, but earlier commissions, before this particular last effort, I read it as saying, look, television, radio, newspaper, they're all in the business of providing news. They're all somewhat competitive, and we want to stop them from being concentrated, so we have our rules. And one thing about those rules, one thing only, is that they will not hurt small businesses. They will tend to help small businesses enter more easily, and small businesses tend to be correlated with women and minorities. Now, we have a change. And the change seems to be, we don't see any effect. Okay? Now, normally, when an agency changes its rules, it has to explain why. Just a question of explaining it. Well, that's the same question I asked before. What's the theory? Where's the explanation?
Well, with respect, Justice Breyer, the earlier commission never said it was keeping the rules for the purpose of promoting minority and female.
No, I'm not saying for a purpose. I am doing it the opposite way. There is no negative effect on small businesses. In fact, it's positive. And looking at the public interest generally, there's no negative, and it's a positive for women and minorities. Then they change. Okay? Where's the explanation?
I don't think the commission ever said what you are hypothesizing. They have never said, even in the 2016 order that predated the reconsideration order, that the rules would help. The structural ownership rules, it's important that we be specific, that would help small businesses, new entrants, minorities, and women by correlation. They did say that with respect to the diversity order, that the Third Circuit, without any explanation, threw out. But the 2016 order that predated the order on review actually never said that the ownership limits would advance the interests of even new entrants.
Justice Alito?
To paint a picture of what this case means in real-world terms, can you give me a concrete example of some beneficial development that would occur if the Commission's rule is sustained, but that will be prevented if it is not sustained?
For example, Justice Alito, a local broadcaster might buy a failing newspaper. That would be a very good thing. As the record shows, and many of our amici explained, newspapers have been in a downward spiral for decades. A local broadcaster could buy that newspaper, help get it back up and running, and be providing more local news and more local content for the community. That would be an excellent thing that would not be allowed to happen if the Third Circuit is not reversed. And on that point, Justice Alito, if I might, it's important to note that respondents have not even challenged the Commission's statutorily required competitive findings. Why? Because there really is no serious argument that these rules still are necessary.
Is that a realistic possibility? Can you point to a real-world example of a local television station buying a failing newspaper and keeping it in business?
I believe the amicus brief of the affiliates lays out in detail a lot of examples where television stations have been able to do that, or buy another television station in the same market, pool resources, and create more local programming. So I refer you to those amicus briefs. But Justice Alito, another real-world point is that, for instance, Amazon gets to own the Washington Post today. Nobody thinks that's the end of democracy. It's surely not the end of democracy if a local broadcaster can buy a local newspaper and keep it alive.
Thank you.
Justice Sotomayor?
Counsel, the way you want us to rule requires us to go through the FCC's history with this issue, starting presumably in the 1970s, and now going over close to 50 years, practically. You're encouraging us not to look at what might be a simple issue, which is, was the explanation given adequate? I don't know why either you or the Solicitor General need to go that far. Could you explain to me if there's a simpler reason why we should go to the more complex reason?
Well, I actually think the statutory reason is not as complex, but I'll get to that next. The reason why we, the broadcasters, are asking for statutory relief is because it took us 17 years to get to this court. 17 years of litigation where the Third Circuit was distorting the statute the entire time. We badly need a course correction, and I think the lower court...
Well, part of that problem is not with what the Third Circuit did. It's what the government did. The government was acceding to the Third Circuit's jurisdiction up until this moment, meaning at every moment in which there had been a motion to transfer the case, the government agreed to it.
Yes,
so I don't think you can blame the Third Circuit or the fact that it retained jurisdiction for what the government encouraged.
Well, it was the Third Circuit's dilution of 2028 that's also the problem. But you're right, Justice Sotomayor. We've not been aligned with the government in all steps, and that's why we're here trying to protect the interests.
So I put another question. You have not told me or given me a line to draw as to when it's appropriate or inappropriate for a circuit to retain jurisdiction in a complex case.
I don't think you need to draw a hard line, but here it's clear we're way outside of anything appropriate. One panel of the Third Circuit has retained jurisdiction for 15 years over 4 successive separate quadrennial review orders. That's excessive, I think, by any standard.
Justice Kagan?
Ms. Walker, I'd like you to assume with me that in applying its public interest standard, generally, the FCC has always thought of one factor, not the only factor, obviously, but one factor is minority and female ownership. And I'd further like you to assume, and I understand that you can test this as a factual matter, but I just want you to assume it with me now, that historic practice has been true in the 202H context, as well as in rulemaking or license giving or anything else that the FCC does. If you assume those things, what obligation would the FCC have to say why it was not taking in that consideration into account here?
Well, we think the statute actually would preclude consideration of that factor here, even if the Commission wanted to. I draw your attention to our statutory theory, which is that the public interest here has to be cabined in some way. And so we read the statute as asking the Commission to go back to the original public interest rationales for whatever rules they are reviewing under 202H. And here, everybody agrees that would not include minority and female ownership.
So you're saying that, I'm sorry, if I just make sure I understand, you're saying that even though the FCC can use minority and female ownership as a factor in doing rules generally and in giving licenses, when it comes to 202H review, they affirmatively cannot.
Not if it was not an original basis for the rule. And why does that make sense, Justice Kagan? Because it keeps the Commission to the task of reviewing what it has done before, not coming up with new rules or new rationales to even add ownership restrictions.
I think well, I think my time is up, so I'll quit there.
Justice Gorsuch.
Good morning. I wanted to return to the question Justice Sotomayor raised, and that is, what's at stake here between your rationale and the FCC's? I guess you ask us to rule on a statutory basis. The FCC asks us to rule that it's reasoned decision-making basis. I would have thought perhaps a win's a win from your client's perspective, and I'd like to understand why that's not the case.
Well, as a practical matter, Justice Gorsuch, if this court doesn't clarify what the statute requires or doesn't require, we're going to be back in this very same morass in the next quadrennial review, the 2018 quadrennial review that's on ice, pending the outcome of this court's decision. If the court merely holds that the Commission adequately explained a completely atextual factor that the Third Circuit imposed unilaterally on the Commission, we haven't made much practical progress, because that might even embolden courts to add other atextual factors. Today, it's minority.
Let me interrupt you there. I mean, if this quadrennial review is allowed to go forward and the experiment is allowed to play out and data is obtained, presumably you have confidence in the results. They'll show great public benefit. Why wouldn't that be sufficient for the day?
I think the problem, Justice Gorsuch, is that respondents' theory of the statute would allow the Commission to add totally new theories as a reason for keeping rules, so we'll never have any regulatory reform, or worse, tightening the ownership restrictions. Congress definitely did not think that 202H was supposed to be a vehicle for tightening the ownership.
Well, on that, I mean, you play by the sword, you die by the sword, and if you adopt and permit a statute as broad as public interest, you can't be surprised when it winds up including nothing or everything or something in between.
But this statute doesn't just say the public interest. It says the public interest as the result of competition. And we've offered a reading that ties that, anchors it in the purpose of the statute, which is regulatory reform. This is not a freestanding reference to the public interest like there is in other parts of the Communications Act and elsewhere in the federal law. It says as the result of competition, and those words have to mean something.
Justice Kavanaugh?
Thank you, Chief Justice, and good morning, Ms. Walker. What do you do with the next sentence of the statute, which does refer to public interest in isolation?
That sentence textually links back to the first sentence. The first sentence tells the Commission that it shall determine whether any of the rules are necessary in the public interest as a result of competition. The second sentence tells the Commission what to do if it makes that determination that certain rules are no longer necessary. If it makes that determination, it has to repeal or modify them. So the determination referenced in the second sentence is the same determination referenced in the first sentence, so they textually link to each other, and it would have been pedantry for Congress to have to repeat as a result of competition after the words the public interest in the second sentence of the statute.
Do you agree that if the term is public interest in isolation, that an agency has discretion to interpret that to encompass effects on women and minority ownership?
I think it could, but it never did that here. And so the Third Circuit was wrong to say that that was a requirement under State Farm. And if it is a freestanding public interest standard, Justice Kavanaugh, I think that raises non-delegation problems. We've offered a reading that ties the public interest to the task and the unique context of this particular statute. And NBC says we have to pay attention to statutory context here. And the text, the context, and the purpose of this entire statute all point in the direction that Congress meant this to be a vehicle for deregulation, not more regulation.
Thank you, Ms. Walker.
Justice Barrett.
So, Ms. Walker, given that Congress wanted the statute to be a vehicle for deregulation, not more regulation, is it your position that the word modify in 202H, when it requires the Commission to modify or repeal as part of its quadrennial review, that a modification can never be an additional regulatory requirement?
Yes, we agree with that reading of modify.
Is it your... Oh, go ahead, Ms. Walker. Please finish.
I am finished. We agree.
Okay. Then let's talk about the public interest and how it might affect a repeal or modification of a rule. Let's imagine that the Commission finds that a rule no longer promotes competition, but believes the rule promotes viewpoint diversity and localism. In that event, is it your position that 202H requires the FCC to repeal or modify the rule?
No, the Commission gets to balance the traditional public interest factors on our reading of what the public interest means. Those are all three factors that underlie these rules: viewpoint diversity, competition, and localism. The Commission gets to balance those, but it can't make up brand new reasons. And I just want to reemphasize, Justice Barrett, that in this order, if you read it carefully, you'll see that the Commission had already made the public interest determination required by the first sentence by the time it got to the discussion of minority and female ownership. At that point, the Commission had no choice but to repeal or modify the rules, because the second sentence makes that mandatory.
Thank you, Ms. Walker.
A minute to wrap up, Ms. Walker.
Thank you, Mr. Chief Justice. Section 202H was enacted 25 years ago. Since then, the ownership rules have barely changed. That is not what Congress had in mind. And it took us, as I mentioned, 17 years of litigation to get to this court. Now that we are here, we respectfully ask the court to provide guidance on what the statute does and does not require. Absent that guidance, we're going to be stuck, most likely, in the same morass in the very next review, and Congress's intent could be thwarted for another 25 years. We thus respectfully ask that you clear the way for the statute to finally operate as intended, as a mechanism for meaningful reform with a focus on competition that does not allow atextual factors to trump the Commission's expressly required competitive findings, which, again, are here completely unchallenged. For these reasons, we ask the court to reverse the judgment of the Court of Appeals and instruct it to deny the petitions for review. Thank you.
Thank you, counsel. Ms. Deutsch.
Thank you, Mr. Chief Justice, and may it please the Court. This is an APA case about whether the agency engaged in reasoned decision-making. The government agrees that promoting broadcast ownership by women and people of color has long been the Commission's own public interest goals, one that is fully consistent with the statute and is not a command imposed by the Third Circuit. The government also agrees that the agency must reasonably weigh all competing aspects of the public interest that it has identified in its quadrennial reviews. The problem here is that the reconsideration order fails this basic requirement of administrative accountability. Based on zero information about female ownership and a nonsensical analysis of badly flawed data on minority ownership, the agency repeatedly assured the public that consolidation would do no harm to either. The government now asks for deference. It says that the uncertainty was acknowledged, prediction is hard, and it argues essentially that because no harm was shown, there was nothing to be weighed. But because the no harm findings here were wholly arbitrary, to defer on this record would only encourage agencies to do sloppy work to avoid making tough choices. Ultimately, if the Commission wants to give less weight to ownership diversity or even abandon the goal entirely, nothing in the Third Circuit's ruling stands in its way. But what the Commission cannot do, under time-honored principles of administrative law, is mask important policy changes behind such unreasoned analysis. Thank you, and I welcome your questions.
Counsel, let's say the Commission, there's sort of two different priorities, priority A and priority B, and the Commission is going along focusing on priority B, and then, there's a change in the Commission membership or whatever, and the Commission says, well, we're now going to focus on A. Nothing to do with the record or findings or inadequacies on issue B. We just think that issue A is more important. How is that subject to APA review?
At the minimum, there needs to be, as this court said in Fox, an acknowledgement that there had been a change in policy and then an explanation of why. Here, of course, there was no stated change in the policy goal of promoting minority female ownership, and there were repeated assurances that the deregulatory measures going forward would not harm that goal. And
Is it enough for the agency to say, you may have noticed we're no longer talking about B, we're talking about A, and the reason is we think A is more important than B. Is that enough?
I don't believe that's enough, Your Honor. I think they would have to say why it was more important.
Well, how do you do that? If they're apples and oranges, but, life is short. They only have so much time. And they think cross-ownership is more important than minority and female ownership. Those are two different things.
Well, one thing they could have done here, for example, is to say, no matter what the harm to this other longstanding policy goal, which we have said on many occasions that our broadcast ownership rules are to promote, and I would point you to JA 335 and also the 2002 order cited on 32 of the NABRIS. They could say, no matter the harm to this goal, it's really hard to measure, it's too uncertain, and we're willing to go forward for these other public interest goals because they are more important. But they did not say that here.
Well, if their action focuses on a different set of priorities, in other words, you seem to be suggesting that as a matter of policy, as opposed to what the record shows about a particular priority, they have to justify a determination that A is more important than B, when reasonable people can disagree on that. They can't just say, yes, this is female and minority ownership is a very important thing, but so is cross ownership, and we can only, as I said, we don't have resources to devote to both, and we're going to focus on cross ownership.
I think they would also have to say that we're willing to do that no matter the harm to something that we have repeatedly said is one of the goals of these rules. What
is the basis for the Third Circuit's ruling? If you're going to shift, you have to say that it maximizes the benefit to the priority that you're no longer pursuing.
I don't believe the Third Circuit went so far. They said that you had to weigh the effects and left the Commission ample space to weigh those effects and come out in favor of deregulation and balance as they saw fit.
Justice Thomas?
Thank you, Mr. Chief Justice. Counsel, I'm just a bit confused. Petitioners indicate that in the past, these structural ownership rules simply did not include minority and female ownership considerations. Could you address that and include in that at what point did those considerations, I'm not talking about the standalone rules, such as, tax preferences, et cetera, but just these structural rules. They seem to indicate that these rules are different from those standalone rules on minority and female
Justice Thomas, and I'm happy to point you to several places, starting in 1995 in a local TV rule that was predated Section 202H. The Commission recognized that the potential for increased prices from the relaxing ownership limits, and it concerns us considering the ability of minorities and women, and committed to studying the effects of that. Then the 2002 order, I guess, is where I would go next. That's on the NAB brief at page 32. The Commission stated how it, quote, had historically used the ownership rules to foster ownership by diverse groups such as minorities, women, and small businesses. In JA 335, the Commission again says that it has a long history of promoting rules and regulations intending to promote diversity of ownership among broadcast licensees, including minority and female owned businesses, and as explained above, the Commission's broadcast ownership rules help further this purpose. So while they're not targeted measures, they create the underlying structural, and I have many other examples, but those are the highlights. And
well, what's the difference between what you just said and the idea or the notion that the object of this rule is to promote program diversity of viewpoint, and these other benefits are collateral benefits? And as I hear the argument, the petitioners suggest that you don't sacrifice or you don't veer away from the central purpose of viewpoint diversity for these collateral benefits, though they may be worthy. What's your response to that?
Well, the Commission has talked about fostering diversity by historically underrepresented groups both as a freestanding interest in terms of having fair and equitable allocation of the scarce broadcast spectrum, and one that is intertwined and supports the other public interest goals. Not only viewpoint diversity, and there's record evidence on that at JA 335 again, JA 397, but also a benefit to other public goals like localism, and the NAB brief of 23 states puts that evidence there.
But can you promote, I'm sorry to interrupt you, but can you, what if focusing on the collateral benefits impedes disposing of the primary object, which is, again, as the petitioners argue, viewpoint diversity?
If the Commission reached that conclusion after a reasonable weighing, that would be fine. But that simply didn't happen here. There was no weighing whatsoever.
Justice Breyer?
All right, you read the briefs on the other side. There's an amicus brief that explains, economically speaking, why they want to get rid of the rules. It's a combination of failing company argument, economies of scale. So they have that before them, the FCC. Now, they didn't say they're abandoning the minority women policy. They didn't say that, or the small business policy. What they said is there's no evidence in this record to convince us that if we do what these kinds of briefs say, that it will hurt our efforts there. And besides, we have two new things called incubator, and we have something called eligibility, and we're trying to preserve and encourage minority and women ownership that way. Okay? What's wrong with that? And you heard me ask the other side,
well,
hey, aren't they changing their policy? And the other side says, no. There's nothing that said in the past that the policy is different than that.
So, I mean, the main thing wrong with that is that the assertions that are strewn throughout the reconsideration order that the deregulatory moves will not harm minority and female ownership.
That isn't what they said. There's no evidence. They have a couple of sentences there, which you've read.
Yes, but they
now,
also
why, in heaven's name, did you not, or groups that support you, given the tremendous number of people who I'm happy are interested in this, why aren't there some studies or something? There are 10,000 law professors and economics professors who look for studies to do. Why isn't there something?
Well, there is something on this issue which they ignored, even as they cited one.
Okay, what?
The Free Press study. Why did they ignore it? Or
okay, that's Is there anything other than that?
Yes, they have their own study that's titled "Whose Spectrum Is It Anyway?" that was cited in comments in the 2014 further notice of approval.
Okay, I'll look at this.
Yeah, and I would just say that there's a lot of wiggle room in the reconsideration order, especially, but I would point you to the statement that the repeal of the NBCO rule will have no material effect on minority and female ownership. The repeal, that's at 87A. The TV rule repeal is not likely to harm minority and female ownership, will have no negative impact. That's 121A. And again, these statements abound, and they are framed as findings and determinations. And when you look at what they're actually based on, it's that listing of numbers on page 37 of our brief that has nothing on women. And as for the minority data, the American Statistical Association is here telling you that it is worse than doing no analysis at all to draw the conclusions that they drew.
Thank you.
Justice Alito?
In your briefing, you argue that the petitioners forfeited any constitutional argument that the FCC could not consider minority or female ownership. Would you therefore agree that there is no need for the court to consider that constitutional question?
Absolutely, and I would also point to this court's decision in the first Fox case, where it recognized that until the administrative law analysis of whether the underlying decision to be made is a reasoned one, and you've addressed any arbitrary and capricious concerns, then it's premature to reach the constitutional question.
All right, thank you.
Justice Sotomayor?
Counsel, you're relying on the free press data. Could you give me your best authority for the idea that the FCC was required to utilize the free press data?
I would point you to the administrative...
And is there any, and let me just follow up, and is there any requirement for it to have needed to explain why it didn't rely on it?
I don't have a case at hand, Justice Sotomayor, other than the bedrock cases like State Farm. But, you know, having cited one of the free press data points in its listing of numbers, and then having ignored the results from that study that at least attempted to do a more reasoned analysis of the exact same question that the FCC purported to analyze in that listing, it's a little bit like throwing stones from glass houses for the agency now to be here saying that the free press study had its own problems. And so, you know, I think it's just bedrock ad law that they need to, at the very least, explain why their analysis was better than the free press study, which they patently could not do.
Finally, I don't think you're disputing that the agency gets to decide how important it thinks minority and female ownership is in the context of any given rulemaking. And I don't think the agency has changed its position that its ownership rules are not primarily intended to promote minority and female ownership. So how do we reconcile that with your position?
I think it's, again, this is standard arbitrary and capricious review, which we told the court at the petition stage. The agency gets to set the goals consistent with the statute, and a reviewing court can only look and see whether they did what they said they were going to do and offered a reasoning explanation. The government here admits that if harm had been found, they would have had to weigh that harm. It would have to the extent to see whether it cautioned against the consolidation it wanted to go forward with. And, you know, we disagree that that there was no harm to be found on this record. They didn't, especially for women.
Thank you, counsel. I think you've gone over my time.
Thank you.
Justice Kagan?
Ms. Deutsch, you began your argument today by saying that the government agrees with you that minority and female ownership should be taken into account in decision-making like this. But as I understand what the government has done this morning, is to say that they don't agree with you. I mean, this is unlike in their briefs, but at argument, the government has said, well, with respect to 202H determinations, we've never taken into account female and minority ownership. And Justice Thomas asked you a similar question, but I just wanted to make sure that you had the opportunity to respond to that assertion of the government's that it had historically not taken female and minority ownership into account in the 202H context specifically.
I didn't. It's a better question for Mr. Stewart. I agree that it hasn't been the only factor or a primary factor, but to the extent that Mr. Stewart was saying that it had never been considered as a factor, I think that's just not consistent with history. And then,
well, I guess I'm really giving you an opportunity to tell me what to look to decide whether you or Mr. Stewart is right on that question.
Thank you. So, again, I would look to the earlier orders cited at page 6 and 10 on our brief that are predate 202H, and then the first 202 review, 2002 review under 202H, defines the policy goals and said we will first define our goals. We can then assess whether our current broadcast ownership rules are necessary to achieve these goals. Then talks about the 5 types of diversity, which include minority and female ownership as one goal, and says, and this is at 18 FCCR at 13.634, encouraging minority and female ownership historically has been an important commission objective, and we affirm that goal here. And then, again, JA 335 talks about how the Commission's broadcast ownership rules help further this purpose of promoting minority and female ownership.
So, Ms. Deutsch, suppose that that's right and that the Commission has historically considered this as one factor in its broader public interest analysis. But here the Commission says something along the lines of, look, there's actually not a lot of data about how this rule will affect minority and female ownership. To the extent that we have data, we think it shows that it won't have an impact, and so we're going to go with this new rule. Why isn't that enough?
Because it would be an important break with past commitments, not only the repeated promise to collect data and analyze this problem, which, as I said, goes back to the 1995 TV rule. But
are you saying that the Commission has a freestanding obligation to go out and collect data itself with respect to this? The Commission can't rely on the notice and comment process to provide it with data?
The Commission has its own data already that it collects in the Form 323 form. So no, I'm not saying that, but I think what was wrong with your first formulation, or how it might have been, more passable, was if the Commission had said, we can't figure it out, it's too uncertain, put to the one side our promises about figuring it out better, but we're willing to move forward no matter the harm to this goal, even though we still think this goal is important, but we just, we're throwing up our hands. We can't do it.
Thank you.
Justice Gorsuch.
I'd like to pick up there. As I understand it, it'd be okay for the Commission to say, we're going to try this no matter the harm to other goals. Why isn't what they did better than that? And what are we supposed to do about it? The 1970s, and we have 1970s rules governing cross-ownership still today. And the one thing we know about the 96 Act is it had a deregulatory impulse. And yet that impulse has never been exercised. The idea, I think, was to have experiments every 4 years and see how it goes. And the agency sought all the data it can get. And as Judge Sirica pointed out, one can parse it and complain and fly-spec it, but isn't the best source of data an experiment? And isn't the agency in something of a catch-22 position? Judge Sirica wonders. What do you say to those thoughts?
I have a bunch of responses. First, it's hardly fly-specking evidence to assert that there will not be no harm, for example, to female ownership when you have zero information.
But as you know on that, they say that there isn't good data available. And in response to a prior Third Circuit order, they publicly solicited all the data anybody in the country could provide.
Well, there were analyses of that, but going to the larger point of the commission's being stuck, the FCC has much to do with the delays here. I mean, Prometheus 3, for example, was the Third Circuit simply telling the agency to hurry up. And we're here in 2020 looking at an order cycle that began in 2010.
I guess that doesn't address my fundamental question, though. We're stuck with rules from the 1970s that 20 years ago, 25 years ago, Congress said were outdated. And when is the FCC going to be able to try an experiment? And if it says in its best considered judgment after multiple rounds of remands and multiple rounds of data collection and public comment, that it earnestly believes that these rules aren't going to negatively impact anyone and might actually affirmatively benefit most people, when exactly is it allowed to see and experiment with that for 4 years and then collect the data and see what actually happened?
Well, a few things. First, the agency tomorrow could issue a separate rulemaking on the NBCO rule, for example, apart from the 202H process, and nothing impedes that. Second, there's no experiment now and see what happens, I think, reasonable reading of 202H, which requires the agency to assess, as competition has changed, whether the rules are necessary in the public interest at that moment. It isn't a license to move forward, no matter the harm to one of your own public interest goals, and then, sort it out later, particularly because, as we argue in our brief, the sorts of harms here from unwarranted consolidation cannot easily be undone.
Let me ask you a question about the retention of jurisdiction here. I understand that courts obviously have the practice of sometimes deferring to another court and consolidating matters voluntarily. But what authority is there for the Third Circuit to have retained jurisdiction over not one rulemaking, but now 3 over the course of 15 years? That does seem a little unusual in its duration and in the number of rulemakings involved. I think Judge Williams called it contrary to the goals of Congress.
Well, Justice Gorsuch, our view is that it's a proper exercise of that court's jurisdiction, and the government never challenged it below. It happens sometimes, although not frequently, for similar cases that have long and complicated histories and also a history of agency delay. And, of course, the court can modify that ruling to the extent that it sees fit. But it doesn't undermine the core problem here, which is the arbitrariness of the reconsideration order. And on that basis, certainly the Third Circuit should be affirmed.
Justice Kavanaugh?
Thank you, Chief Justice, and good morning, Ms. Deutsch. You've referred, I think quite rightly, to administrative law basics a few times in your answers, and I want to get your reaction to one way to look at this. Courts obviously review agency legal interpretations to make sure the agency is not departing from the law enacted by Congress, and on that front, reviewing the law, our review is usually pretty tight, pretty stringent, putting aside whether there's an ambiguity in the law. On the other hand, and critically, federal courts do not make the policy calls. We defer to agency policy judgments within the constraints imposed by Congress. And here it's the broadest possible language that Congress uses, public interest, not much of a constraint at all, a broad, and Ms. Walker alluded to, arguably too broad a delegation. But that doesn't give us much to work with. And then arbitrary and capricious review, and Judge Sirica said this many times, is highly deferential to the agency's policy judgments. And there's a lot of case law, as you know, in the FCC context, Justice White's opinion for the court in the WNCN case, that predictive judgments made by the agency get especially significant judicial deference. And so at the end here, it's deferential on the policy, the public interest standard. They made a predictive judgment. How can we, sitting here, second guess all of that?
Well, a few things, Your Honor. I agree completely that the agency's reasoned predictive judgments are afforded deference, and that's, APA 101. But here there's no reasoned judgment to defer to. There is nothing there on women, no data and no explanation even, or attempt to explain why the no harm finding that's arbitrary and on its own terms that they drew for minority ownership would also transfer automatically to women. In cases like WNCN, NCCB, Fox, in every one of those cases there is at the very least a reasoned decision tree set out by the agency of why they're doing what they're doing and how they're weighing the pros and cons. Well, the government agrees to weigh, and they say, well, we don't have to weigh because we don't have any evidence of harm. But ignoring evidence of harm doesn't make it go away.
And what do you say, and you might have indicated this to Justice Breyer, but what do you say is the absolute best evidence in the record for you that scaling back these rules will negatively affect women and minority ownership?
Well, certainly the Free Press study, which is cited in our brief and cited by the government in its analysis. And I would also point you to one of the early reviews where the commission itself recognized the drop in minority and female ownership after the consolidation in the late 90s, and that's cited in our brief at 10 at 15 FCCR at 11084. And also, the Free Press study, in addition to doing the historical trend analysis for minority, also did cross-sectional analysis for both people of color and women-owned stations, and showed that the more consolidated the market, the less likely there was to be representation by these groups.
Last question. To what extent, if any, should we take into account that during the pendency of this litigation, the local news industry has been decimated?
Well, I think, I'm not sure that's in the record, but, I think to the extent you want to take account of what's happening after this record has closed, there's a much easier path forward, which is to affirm the Third Circuit and let the already delayed 2018 review move forward, including analyzing the results of the incentive auction, which is another area where the data indicated that women and people of color were disproportionately exiting the market.
Justice Barrett?
Ms. Deutsch, I have a question about the Free Press study. So wasn't and maybe I'm not fully understanding its scope, but I thought the Free Press study was largely backward-looking. So, for example, on page 39 of your brief, you talk about how its tracing concluded that the 1990s television rule changes contributed to the loss of 40% of the previously minority-owned stations. Was it entirely backward-looking, looking at the effects of rule changes in the past, or did it have a predictive component?
The trend analysis was backward-looking, just like the government's analysis of the numbers was. Just did it better by using better numbers that were corrected for the problems in tracing. But as I said, they also did cross-sectional analysis, so taking a snapshot in time, showing that the more consolidated the market, the less likely there were to be women and people of color owners.
And so to be sure that I understand that, you're saying that they did make a predictive judgment. It offered predictive analysis, like if you make this change, then this is the likelihood that this will happen, this being the decrease in minority and women-based ownership?
I don't think it went so far as that, but it was an inference that could be drawn from that analysis.
Well, if it's just an inference that could be drawn from that analysis, why isn't the commission correct that there was no evidence in the record that showed there would be harm?
because its own numbers, even without any correction, showed that there was harm from past consolidation, and there's no reason to think that wouldn't happen from future. Plus, as I said, there's this other study called Whose Spectrum Is It Anyway? It's cited in the notice of proposed rulemaking in 2014, and in some of the comments that interviewed about 100 market participants that chronicled the difficulties faced by more diverse owners under consolidation.
But is that your position? You talked in your briefs about the need for statistical evidence and the fact that the government had no evidence at all in the record about the effect on women ownership, as opposed to the minority evidence, which you say that it ignored. But if there's no statistical evidence, and I hear you saying you're talking about the backward-looking free press study, you're talking about interviews, is there anything in the record that's actually a statistical analysis that shows the likely impact of these changes on the relevant minority and women community?
Other than the sources I've mentioned, no.
Thank you, Counsel. I don't have any other questions.
A minute to wrap up, Ms. Deutsch.
Thank you, Your Honor. I have 3 points. I'll try to go fast. Minority and female ownership, I just want to reiterate, has long been baked into the public interest standard in this context. I've read you some of the quotes. Industry petitioners are up against the government, former commissioners, and history in contending otherwise. Second, the government agrees that a reasonable weighing of all public interest goals that they have defined in this context is necessary, and that simply didn't happen here. On this record, there's no reasoned predictive judgment to defer to on gender or on minority ownership trends, and the agency didn't make, much less attempt to explain, its decision to deregulate no matter the harm to its own public interest goal. And just the opposite, there are unfounded statements that permeate the reconsideration order about how the rule repeals will have no material effect or will not likely harm minority and female ownership. And although they talk a lot about the newspaper broadcast cross-ownership rule, for the local TV changes, for example, that is the only evidence that they rely on for no harm is this listing of numbers on page 37 of our brief. Finally, I would note that the remedial concerns don't undercut the Third Circuit's core conclusion here, that the Commission undertook dramatic regulatory repeal without reasonably considering an aspect of the public interest. I think it continues to espouse the colloquy with Mr. Stewart notwithstanding. The court can tweak the remedy as it sees fit, but the best course is to allow the Commission to consider these questions afresh in its 2018 review, where it can analyze the better data, including the full results of the incentive auction, to reach a reasoned decision on whether deregulation is actually in the public interest. For these reasons and others in our brief, the Third Circuit should be affirmed.
Thank you, counsel. Rebuttal, Mr. Stewart?
Thank you, Mr. Chief Justice. Let me first clarify our position with respect to the potential impact of minority and female ownership data on the cross-ownership rules. My primary point is that when those rules were first adopted, they were adopted for reasons other than their potential effects on minority and female ownership. And so the Commission, in deciding whether to retain those rules, has naturally focused on whether the original justification continued to apply. Now, in the era post-1996, the enactment of the Section 202H, you can find documents that list basically the full range of public interest considerations as potentially relevant to the 202H reviews. But I'm not aware of any instance, even under Section 202H, in which the FCC has actually amended, repealed, or retained a cross-ownership rule for the stated reason of its impact on minority and female ownership. It just historically, either before or after 1996, has not been a factor that has animated the Commission's decision with respect to the ownership rule. Second, I think the most straightforward path to decide the case is to follow the one that the Commission itself laid out in the reconsideration order. It said the historical reasons for the cross-ownership rules no longer apply. Allowing cross-ownership will likely benefit consumers. acknowledged that incomplete data left uncertainty as to the likely effects of repeal and amendment on women and minorities, but the agency's best estimate was that there would be no harm, and the bare possibility of harm was not a sufficient ground for foregoing changes that the agency otherwise considered highly beneficial. The court has said numerous times that it will, quote, uphold a decision of less than ideal clarity if the agency's path may reasonably be discerned, and I believe the agency's path can reasonably be discerned here. And third, I'd like to focus again on the quadrennial review scheme that Section 202 lays out. People have referred to the deregulatory thrust of the 1996 Act, and that's correct, but the principal purpose of Section 202H was to ensure that cross-ownership rules didn't remain on the books through inertia, that if they remained in place, it was because the Commission had re-examined them and had made a fresh determination that they continued to serve the public interest. And the Third Circuit's approach really thwarts that. If the cross-ownership amendments had been allowed to go into effect in an earlier year, we will now have more data on the potential effects of those rule changes on minority and women. The effect of the Court of Appeals decision is that the periodic review process can be derailed by commenters who identify possible countervailing effects and insist that the agency perform new research before it can amend the rules that are already in place. That has the very effect that Congress attempted to forestall in requiring quadrennial reviews.
Thank you, counsel. The case is submitted. We will now hear argument in case 19-1189, BP P.L.C. versus the Mayor and City Council of Baltimore. Mr. Shanmugam.
Thank you, Mr. Chief Justice, and may it please the Court. This case presents a question of statutory interpretation involving the provision authorizing appellate review of certain remand orders. The relevant provision of Section 1447D authorizes appellate review of a remand order where a ground for removal was the federal officer or civil rights removal statute. By its plain terms, the statute permits review of the entire order, not particular issues. The Court of Appeals' contrary interpretation is invalid. Respondent offers virtually no textual defense of that interpretation, relying instead on case law, policy, and an alternative interpretation. But those arguments cannot trump the statutory text and in any event lack merit. As to case law, this court and the courts of appeals have consistently interpreted statutes permitting appellate review of an order to authorize plenary review, and respondents' two contrary examples involve unique considerations. As to policy, the plain text interpretation is consistent with Congress's special solicitude for cases involving civil rights and federal officers. That interpretation accords with the background principle of plenary review, would lead at most to marginal additional delay, and could actually expedite resolution of the appeal. And as to respondents' alternative interpretation, a defendant removes a case pursuant to the federal officer removal statute when it invokes the statute in its notice of removal, regardless of the merits of that ground. The sole remaining question is how best to dispose of this case. The court should reverse the judgment below because respondents' claims necessarily arise under federal law. This court's precedents dictate the common sense conclusion that federal law governs claims alleging injury caused by worldwide greenhouse gas emissions. The Court of Appeals should have reached that ground for removal, and it should have held that the case was removable on that basis. The Court of Appeals judgment should therefore be reversed. I welcome the court's questions.
Counsel, you just said that your theory applies regardless of the merits of the federal officer or the federal civil rights basis for removal. What if those bases are frivolous, that everybody who wants to keep their case in federal court will put in as many grounds for removal as they can, and all they have to do is tack on one of these federal officer or federal civil rights grounds. Is that right?
In that circumstance, sanctions and fee awards would be available, as they always are whenever a litigant makes frivolous arguments, and a party could be subject to sanctions up to dismissal. Mr. Chief Justice, I don't think there's any evidence that parties engage in that conduct in the circuit that most clearly has adopted our rule. The Seventh Circuit, there's simply no evidence of that. And
what if it's beyond frivolous? What if the Court of Appeals just says, I think we ought to look at this, and if there turns out they're wrong about the federal officer basis, we'll just send it back, and we don't have to consider all these other possible grounds?
Well, I don't think that a court can do that because the statute obligates an appellate court to consider all of the grounds for removal, and it contemplates a situation like this where the federal officer or civil rights ground may not have merit. That is why the use of the word order is so significant. And to adopt a respondent's interpretation, Congress would have had to make clear that the question or issue of federal officer or civil rights removal was all that was available on appeal, and Congress obviously did not do that.
Justice Thomas?
Thank you, Mr. Chief Justice. Mr. Shanmugam, I may have missed your last point. Did you say that even if the order or the bases offered by the moving party is frivolous, that it would still have to be considered?
No. I think in that circumstance, the Court of Appeals would have the power to impose sanctions, and those sanctions would include dismissal of the appeal. I think
that's again, I heard you say that to the Chief Justice, but why would that even be a basis for review? I think that's what we're getting at as opposed to the sanctions.
So I think that an alternative option that would be available to the court would be to say on a ground much like that the court adopted in Bell versus Hood, that where the federal officer or civil rights ground is frivolous, there is no appellate jurisdiction. But I think our principal submission would be that sanctions and fee awards are available where that ground is frivolous. My last point to the Chief Justice, Justice Thomas, was simply that where the ground is not frivolous, but simply is found to have lacked merit, as indeed the Court of Appeals did in this case, the Court of Appeals nevertheless has to address the other grounds, and that is because the order that is under review necessarily encompasses all of the grounds for removal that were asserted in the notice of removal.
Just so that I'm clear, you're saying that the courts, once the order is appealed, that the appellate courts have no discretion to consider grounds that were not the basis for the appeal.
Well, the court would have the power to consider all of the grounds asserted in the notice of removal, and that is because what is before the court is the order, that is the command remanding the case to state court. And one benefit of our interpretation is that it gives the Court of Appeals flexibility in the other direction. If the Court of Appeals concludes that there is an easier ground than federal officer removal on which to reverse, it can do so.
Thank you.
Justice Breyer?
Well, one concern would be that if you are right, in considering removal, a defendant will add grounds, federal officer or civil rights. There is a big difference between frivolous and meritorious. It's called uncertainty and possible and who knows. So they'll add on those grounds. It will get over to the federal court. The federal court will say that it's not frivolous, but it's wrong, and therefore they will appeal on everything. And that means added time, added delay in a statute, the point of which, no appeal, is to cut down on the time and delay caused by appeal. So what?
Justice Breyer, I would say two things in response to that. First, in response to the specific concern about abuse, I do think it's important to keep in mind that the federal officer and civil rights removal statutes are relatively narrow. It is certainly not going to be every civil defendant who is going to be able plausibly to invoke those statutes. And again, there's no evidence of gamesmanship or abuse in the circuit that is most
I'm not saying, I'm only saying, is there the evidence point I've got? That's a good point. Is there anything else to say? In the ground where you're a lawyer in your office and you say, this isn't really much, blah, 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 but we better stick it in case we want an appeal. You're not saying it's nothing. It's not something either.
Justice Breyer, I think that would take me to my second point, which is, would it have been reasonable for Congress to have made this policy determination? And I would respectfully submit that it would have been. And again, we have no legislative history that even speaks to this issue. Our primary submission is that the text is clear. But I think that Congress could well have concluded that in light of the significant federal interests that are often in play in these cases, that even in circumstances in which the civil rights or federal officer ground is ultimately found not to have been meritorious, that Congress, balancing the risk of erroneous remands against the risk of incremental delay, could have struck the balance to permit plenary review consistent with the ordinary way that appellate review operates.
Justice Sotomayor?
Counsel, you're talking about what balance Congress could have chosen. But I go to the fact that when Congress added 1443 to the statute, every circuit court who had addressed this issue had already ruled that the only thing that was subject to review was a decision based on 1442 and had rejected your argument. Don't you think that if I'm trying to figure out what Congress intended, that I would look to what was before Congress's in front of Congress in its understanding, number one? Number two, that when it told me that it didn't want appellate review of all issues and that it only wanted appellate review of 1442 and 1443 issues, that our review should be limited to what it wanted? I mean, I do know that we have some of my colleagues who believe that exceptions should not be read narrowly. I don't happen to be one of them, but even if I read order order the way you want, I don't think I can read it in isolation. And I think those two other factors make me believe that what Congress intended is not what you say.
Justice Sotomayor, with regard to ratification, first, the law was hardly settled at the time of the 2011 amendment. It is certainly true that several circuits had adopted respondents' interpretation, but they did so with conclusory reasoning, and most of them predated this court's decision in Yamaha, where the court construed a statute using materially identical language in the opposite direction.
Except that Yamaha had already been decided, counsel, and despite that, those circuit courts were ruling against you.
Well, I think most of the circuit decisions that respondent invokes predated Yamaha. There were a few that postdated it, but our submission is simply that Yamaha ought to be taken into account. In addition, Congress merely added 2 words. It did not reenact the entire provision. It didn't make comprehensive amendments, and it's hard to say with any confidence that Congress's failure to speak more clearly reflects approval of those pre-existing circuit decisions.
Justice Kagan?
Mr. Shanmugam, when you were talking with the Chief Justice and Justice Thomas about frivolous cases, you seemed to want to rely on sanctions rather than a kind of Bell v. Hood rule. And I'm wondering, why isn't a Bell v. Hood rule that says that the court has no jurisdiction with respect to frivolous assertions of that kind, why isn't that the better way to go?
I think that option is available to the court, Justice Kagan, as we said in our brief. And if the court thinks that sanctions and fee awards would be insufficient in this context, knowing that that is what the court ordinarily relies on to deter improper conduct by litigants, I think that the court could adopt a Bell versus Hood-like rule. And again, if there were more evidence that this was a problem and respondent does not cite a single example of the sort of gamesmanship that it posits, then perhaps the court should take that further step. But again, as this court recognized, for instance, in Arthur Anderson in the context of appeals in the arbitration context, sanctions and fee awards paradigmatically would apply in a situation like this, where a party is advancing a frivolous argument and doing that for an improper purpose, namely for the purpose of establishing appellate jurisdiction where there otherwise would not be any. And whether that's a matter of statutory fee shifting or sanctions, Rule 11 sanctions, or even the use of a court's inherent authority, again, the sanction of dismissal would be available, dismissal of the appeal, and I think that that would suffice to deal with those situations.
Thank you very much.
Justice Gorsuch?
I'd like to press on the Bell versus Hood argument a little bit from the other direction. Isn't it a little bit odd to police jurisdiction based on whether an argument is frivolous or not? Wouldn't that seem to be more of a merits determination in the first instance? And for a party arguing that we need to follow the strict language of the statute with respect to our jurisdiction of orders, I'm not sure I understand where this authority to dismiss for lack of jurisdiction, frivolous arguments might emanate, what penumbra it emanates from.
Justice Gorsuch, as I'm sure you're aware, the Bell versus Hood rule has been criticized, including, I believe, by Chief Justice Rehnquist on precisely that ground, and I think it's really a matter for the court to decide whether it
Counsel, you're as familiar with those criticisms as I am, and yet you press the point. So I don't think you can press the point and then say, well, I don't know, the court can do whatever it wants. I mean, you surely have to take a position here.
Well, my submission is simply that the court may wish to consider that, but its decision on whether or not to consider that obviously depends on the court's view on the underpinnings of the Bell versus Hood rule.
So here's this crazy rule that you guys made up, and you can continue to make it up if you want, and I express no views. Is that where we are?
I just want to be clear. The court has repeatedly reaffirmed that rule. It would require an extension of that rule, which applies in the context of a federal district court's jurisdiction, to this different context. And so for the court to do that, it would have to first conclude that it is comfortable with the underpinnings of the rule, and second, I think, conclude that sanctions and fees would be insufficient. And our frontline submission, Justice Gorsuch, is there's no reason to think that those would not be sufficient in this context.
Justice Kavanaugh?
Thank you, Chief Justice. Good morning, Mr. Shanmugam. I think a problem for you here is the ratification doctrine that Justice Sotomayor raised, and best I can tell, all the courts of appeals had not adopted this reading as of 2011, that no court had deviated from that interpretation. What are we to do with that? Are we to say that the ratification doctrine really doesn't have that much force, which I think it sometimes is overused, just speaking for myself, or how are we to get around that here if from your perspective of trying to convince us to adopt your position?
I think, Justice Kavanaugh, that this court can apply its existing precedents on the ratification doctrine and comfortably still rule in our favor. And I made 2 points in response to Justice Sotomayor. The first, that the law was hardly settled, and that at a minimum, in considering the state of law,
it was settled. There were a lot of court of appeals. No one had gone the other way.
But I think that is only true if you take a very narrow view of the relevant question for ratification purposes. And again, I think at a minimum, you have to take Yamaha into account because it was this court's most recent pronouncement involving materially identical statutory language. And this court has made...
Go ahead.
I was just going to say, and this court has made clear that where decisions have only conclusory reasoning, they are not entitled to significant weight in the ratification analysis. And it was really
second question. Sorry, I have to jump in to get a second question, which is, why do you want to be in federal court rather than state court?
Well, I think simply because we believe that the claims here arise under federal law, and the easiest basis for that is the federal common law ground that the Court of Appeals did not reach because of its resolution of the question presented. We believe the answer on that question is dictated by this court's precedents, and that federal jurisdiction is therefore mandated here.
Thank you.
Justice Barrett?
Well, Mr. Shanmugam, let me pick up where you just left off. Don't you think it would be fairly aggressive for us to resolve the federal common law question here, assuming that we agreed with you on the antecedent removal point?
I don't think so, Justice Barrett, because that issue really goes to the appropriate disposition in this court, whether the court should simply vacate and remand or reverse outright. And that issue is fully briefed here, and we believe that the answer is clear under this court's longstanding precedents. And there's also, I think, a very significant prudential reason for the court to reach that issue, because, as you are aware, there are some 20 of these cases pending nationwide in courts around the country, and indeed there are a number of cert petitions in follow-on cases that are currently pending before this court. And I think in light of all of those considerations, it would be appropriate for the court to resolve that question. And the answer to that question is clear, because this court for more than a century has applied federal common law to claims seeking redress for interstate pollution, including most notably in AEP with regard to very similar nuisance claims alleging injury from global climate change.
Mr. Shanmugam, let me interrupt you there and circle back to the congressional ratification point. You know, as Justice Kavanaugh pointed out, the circuits were against you. They'd adopted the opposite position. You pointed out in your briefs that the leading treatise, Wright and Miller, had criticized that rule. Should we factor that in at all into our analysis, that there was some criticism of the rule, even though it didn't come from courts?
I think that's a relevant factor, and I think the government agrees, so Mr. Lucas can speak to that as well. But ultimately, of course, it's the case law that drives the analysis. And when you have a unanimous, clear decision from this court construing materially identical language, and Court of Appeals decisions that really had very conclusory, if any, reasoning, I think that the law was unclear. And when you add on to that all that Congress did here was merely to add two words, 1442 or, I don't think that you can conclude that there is ratification, particularly when you go back to the original version of 1447D in the Civil Rights Act, where Congress was plainly very concerned about the risk of local prejudice. I think that the court should not blind itself to that context in making this interpretive decision.
Thank you.
A minute to wrap up. Mr. Shanmugam?
Thank you, Mr. Chief Justice. So as we've been discussing, we believe that the plain language of Section 1447D resolves the question presented and really does permit an appellate court to review the entirety of a remand order where a ground for removal was the federal officer removal statute. But we do also respectfully submit that the court should proceed to ensure that this case and the many others like it proceed in federal court. There is something profoundly counterintuitive about the notion that these cases, which seek relief for injuries caused by worldwide greenhouse gas emissions, should be litigated in state courts under the laws of different states. This court has long made clear that as a matter of constitutional structure, such claims necessarily arise under federal law. The United States has agreed with that proposition, and resolving that issue now will preserve the resources of the judiciary and the parties and ensure the orderly resolution of these cases. And accordingly, this court should not simply vacate, but reverse the Court of Appeals judgment. Thank you.
Thank you, counsel. Mr. Lucas.
Thank you, Mr. Chief Justice, and may it please the court. This court should hold that Section 1447D means what it says. There is simply no natural way to read the phrase "in order remanding a case" as part of an order remanding a case. Therefore, once Section 1447D authorizes an appeal of a remand order, there is no basis for artificially limiting the scope of that appeal to a particular question. Respondent resists that straightforward reading, but never denies that its approach would give the phrase "in order remanding a case" different meanings in two back-to-back clauses of the same sentence. Instead, respondent pivots to a novel textual theory in its merits brief, based on the phrase "removed pursuant to." But that argument can't be squared with how removal actually works. At the end of the day, respondents' arguments are really about policy, namely a legislative desire to prevent delay. But when Congress has already authorized an appeal of a remand order, considering multiple issues is unlikely to prolong litigation much further and may in fact expedite it. I welcome the court's question.
Counsel, I would like to get back to the question I asked your friend previously. Is the appellate court required to consider those additional grounds for removal or simply permitted to do so? Not with respect to whether the federal officer ground is frivolous, but let's say they just look at that first and they determine it wasn't frivolous, but it just happens to be wrong, and therefore we don't have to look at the other bases.
I don't think in that context, Your Honor, whether this was not a frivolous or bad faith assertion of federal officer removal, that an appellate court could simply close its eyes to questions that were presented and that a defendant had the right to appeal. So no, I don't think in that context they could. But in cases where there is actually abuse, I think as petitioner explained, one of the remedies available for such abuse of appellate process would be a dismissal of the entire appeal.
Are there any grounds on which your position differs from that of the petitioner?
With respect to the question presented, I don't think so, Your Honor. I think we think that the statute here means what it says and that it's just implausible to read the word order remanding a case to mean a portion of that order remanding a case.
What about on the remedy?
On the remedy, we haven't taken a position. We think the court could address the issue in this case, and we think that's important, the federal common law issue. We think it's an important question that the court will need to resolve at some point or another, but we haven't taken a position on whether the court should use its discretion to decide it here. But whatever this court decides to do with that issue, we do think that it should confirm that Section 1447D permits appellate review of orders rather than issues.
Justice Thomas?
Thank you, Mr. Chief Justice. Mr. Lucas, you may be right, may or may not be right on the statutory reading of this, but there's an odd, I can't avoid the odd sense that it seems as though we are smuggling into a review, appellate review of other issues that are not necessarily the issues that are front and center, like federal officer. Could you somehow help me to eliminate that sense of awkwardness?
Certainly, Justice Thomas. I would point you just to the fact that this really isn't that unusual. I think in other contexts, the baseline is really what triggers appellate review doesn't necessarily define the scope of that review. And I think Yamaha is a good example. So there, this court declined to answer the question that was certified in the interlocutory order because it was based on an incorrect premise. And had this court taken an approach similar to the one respondent advocates here, it would be left with essentially adjudicating a question that didn't really matter because it rested on the wrong foundation. And I think you can see this in other contexts, such as with respect to the review of interlocutory orders concerning injunctions, or even with this court's direct review over 3-judge district court injunctions.
I know you said that you're not going to take a position, or the government is not taking a position on whether or not we should get to the federal common law issue. But do you have an opinion on whether or not such there is a federal common law principle on climate change injuries?
Yes, Your Honor. We do think that respondents' claims are inherently federal in nature, and although respondent, like the plaintiffs in the Ninth Circuit Oakland case, has tried to plead around this court's decision in AEP, its case still depends on alleged injuries to the city of Baltimore caused by emissions from all over the world. And those emissions just can't be subjected to potentially conflicting regulations by every state and city affected by global warming.
Thank you.
Justice Breyer?
No, you may go ahead. I pass on this.
Justice Sotomayor?
Counsel, this case is proof of how long a case could be extended if we permit review of every other argument than that raised initially in the complaint. The focus of the cert petition was on the federal officer question and whether other issues could be resolved. But the grounds for removal was 442, and that was what was at issue. So I'm not sure I agree with you that there isn't inherent delay. But let me ask you a couple of things. Yamada was decided in 1996. Congress amended the statute in 2011. In that period gap of 15 years, Wright and Miller had questioned the majority rule, but suggested that it needed Congress to change it because it read the limitation the way that respondents do. So I'm not sure how you get around ratification and that it has to have some meaning, especially when we're talking an exception that could open the floodgates of appellate litigation in the federal system.
Respectfully, Justice Sotomayor, I disagree with that reading of Wright and Miller. I think the treatise there from 1992 was clearly making a textual argument based on the word order. Indeed, it anticipated this court's decision in Yamaha, which came 4 years later. But I think with respect to ratification...
What do we do with the two authors who have submitted briefs saying that they think the natural reading is what the circuits have made it to be?
You can certainly take them into account, Your Honor, but I do think that when we're looking at the weight of authority for ratification purposes, it's important to focus on quality, not just quantity. And I do think that if you look at all of the Court of Appeals decisions that respondent cites in its brief, all of them are very conclusory, and they're not really engaged with the text at all. To the extent there's any analysis at all in these Court of Appeals decisions, they're really rooted in purpose. And I think a good example is the earliest decision that I'm aware of on this subject from the Sixth Circuit in the Appalachian Volunteers case. And on the other side of the ledger, not only do you have Wright and Miller making the textual argument, you also have this court's decision not only in Yamaha, but also in cases in other contexts, going back to the Ironworks case from 1897, construing order as it's plainly understood. So we do think that the question wasn't settled in 2011.
Justice Kagan.
Mr. Lucas, I'd like to give you a hypothetical. Suppose that there is a removal on multiple grounds, including 1442, and then there's a remand, and then the defendant decides that he wants to appeal, but he decides that he doesn't really feel like appealing anymore, the 1442 ground. He just wants to focus on the other grounds for removal. So he abandons the 1442 ground. Would the Court of Appeals still have jurisdiction to decide the other removal issues?
I think in that context, that may well be a situation for a remedy such along the lines of Bell v. Hoods or dismissal or some other form of sanctions if it's an indication that this was really a ground asserted solely to get jurisdiction.
Well, I mean, actually, it's not a frivolous argument. He just doesn't think it's as strong as other arguments, and he abandons it. Is there still jurisdiction?
I think in that context, you could still apply a sort of Bell v. Hood type situation, and I think it would be analogous to the three-judge district court context, where this court, in recent cases such as Shapiro, has reaffirmed that if a party seeks to get a three-judge court jurisdiction, and then this court's direct review under 1253, and the constitutional claim is an insubstantial one, then the entire case can be dismissed.
I guess I don't understand your argument. I mean, I can understand your hesitation in answering the hypothetical the opposite way, but once you answer me in that way, it seems as though you're not really, order doesn't really mean order in the way that you insist that it does.
To clarify, Justice Kagan, I think in that context, these are simply remedies that the court could use. We're not saying that the meaning of the word order changes in that context, simply that if this court is concerned about those hypotheticals and they do arise, remedies would be available. And I would note... So
there is jurisdiction, but the court has discretionary remedies available to it.
Yes, Your Honor.
If that's the case, I'm going to ask, what sense that makes. Do you think that that's really the statute that Congress wrote here, which is a statute that's talked about 1442, but allows the court to exercise jurisdiction in a case in which 1442 is long gone?
I think, Your Honor, the purpose, to the extent we're trying to define one, is that once a case is on appeal under Section 1447D, there's no good reason for a court of appeals to artificially limit the scope of appellate review. And going back to my colloquy with Justice Thomas, I would underscore that this isn't an unusual situation. It happens in reviews of all sorts of interlocutory orders, including in Yamaha.
Justice Gorsuch.
I'll pass. Thank you.
Justice Kavanaugh.
Thank you, Chief Justice, and good morning, Mr. Lucas. I think this is a close call, this case. You have the text that you assert, your reading of the text, and Yamaha obviously helps you, but there are also problems. One is the inequity between defendants, one of whom tacks on 1442 and therefore gets appellate review, the other of whom doesn't have the ability to tack on 1442 and doesn't get appellate review, even though they have the same other attempted federal question ground. So that's one problem, which makes it seem doubtful that Congress really intended this. There's also the gamesmanship problem. And then there's the ratification, which I want to zero in on with you. What exactly would you say about the ratification doctrine? Because if you just read the black letter description of the ratification doctrine and lay it down here, it would seem to apply. So why doesn't it apply?
First off, Justice Kavanaugh, we don't think that order remanding a case can really be susceptible to any ambiguity here. But even if you think that it is ambiguous and you want to rely on the ratification doctrine, I would just underscore that the circuit cases you have here really don't engage with any sort of text. And to the extent there's any reasoning at all, rather than just citations to other circuit court cases, they're really just about purpose. And even at that, it's quite conclusory. And on the other side, I would note that you do have this court's cases in other contexts, but certainly similar ones, as well as the leading treatise anticipating this court's decision in Yamaha based on the text of the statute.
So in that context, you think a prerequisite to applying that doctrine is a conclusion of ambiguity? I don't think all of our cases have said that, but that's your view of how the doctrine should apply?
I think so, Your Honor, and that's at least how I understand cases such as Milner versus Department of Navy and the like. But even if you disagree with me, Justice Kavanaugh, I still think in this context, it's hard to say that Congress thought this question was settled in 2011, which I think everybody agrees is the sort of touchstone of the ratification analysis, when you have on the one side, yes, a number of circuit cases, but they're poorly reasoned ones, and on the other side, you do have this court's precedents in other areas and the leading treatise. So I think in that context, it's just hard to say that Congress would look at this landscape and say that, yes, this issue is firmly and conclusively settled.
Thank you.
Justice Barrett?
Counsel, I want to go back to Justice Kagan's question because I had the same one, the one about multiple grounds for removal. There's a remand order. Do you decide to appeal it? But you decide not to include the 1442 or 1443 ground in the appeal. And when Justice Kagan asked you if there would be jurisdiction, you kind of hedged a little bit and said maybe that was an instance in which Bell v. Hood could be used or sanctions could be used. But I don't see why, so long as the 1442 or 1443 ground wasn't insubstantial or frivolous. So could you say a little bit more about that?
So if no such remedy applies, and in terms of a sanction here, that it's not susceptible to a Bell v. Hood type construction or to a sanction available, then I think the text of the statute would control. But I do think that's going to be rare when you get a context like that, because I think in those cases, it's quite likely that those can be fairly characterized as evidence of bad faith. If a party seeks to gain appellate jurisdiction using one of these grounds and then abandons that argument on appeal, that would seem to me to be a pretty good candidate for an instance of a Bell v. Hood type remedy or a number of sanctions available in the.
Well, I'm not sure about that, because if it was a decent argument, but they just decided not to press it on appeal, I'm not sure that's a candidate for sanction or Bell v. Hood, even if, as Justice Gorsuch was pointing out, we wanted to continue the life of Bell v. Hood any further. But I don't have any other questions. Thanks, counsel.
Mr. Lucas, a minute to wrap up.
Thank you, Mr. Chief Justice. A few quick points. On gamesmanship, I just want to underscore that respondent has neither identified any evidence of abuse in the circuits that review the entire remand order, nor really offered any compelling reason to expect that situation to change. And if problems ever do arise in the limited set of cases where a defendant can plausibly invoke Section 1447D's exception, at the end of the day, they can always be addressed by Congress. In the meantime, the theoretical possibility of undesirable consequences is no reason to carve up undeniably appealable remand orders into reviewable and unreviewable portions. Rather, appellate courts should be able to figure out whether a remand order resulted from a legal error, even if that error doesn't involve federal officers or civil rights. That's how this court has approached other types of orders, and there's no good reason for treating remand orders any differently. Once Congress has authorized an appeal under Section 1447D, it doesn't serve anyone for appellate courts to artificially limit the scope of their review. Thank you.
Thank you, counsel. Mr. Scheer?
Thank you, Mr. Chief Justice, and may it please the court. According to petitioners, merely referring to Section 1442 in a removal notice guarantees a defendant an appeal as of right of every ground rejected by the district court, even if the 1442 ground is meritless and even if the defendant drops it on appeal. That is not a permissible reading of 1447D. That section, a general prohibition subject to a narrow exception, tethers appellate review to two designated grounds, 1442 and 43, and to those grounds only. This court has never held that review of an order necessarily encompasses every issue addressed in an order. Its interpretation of similarly worded statutes proves this. Moreover, the exception clause limits review to removals pursuant to 1442 or 43, meaning where the removal was in compliance with or in accordance with those statutes. The Court of Appeals must decide if federal officer jurisdiction exists, not merely whether a defendant asserted it, perhaps as a bootstrap, to obtain review of grounds otherwise absolutely barred. This case was not removed pursuant to 1442 because, as the courts below held, petitioners do not qualify for federal officer removal. Petitioners' interpretation thus runs counter to the language and structure of 1447D, and even if the language were not clear, their view violates basic principles of statutory interpretation. Finally, petitioners' construction ignores that in 2011, Congress ratified 50 years of unanimous circuit court authority that limited review of remand orders to the exception clause's enumerated grounds and only to those grounds. And the courts in those cases held that the language was clear, and that was what supported their jurisdictional analysis. I welcome your questions.
Counsel, you just said that the petitioner's reading of 1447D is contrary to the language of the statute. I will give you an uninterrupted 3 minutes to explain to me how the language and order remanding a case shall be reviewable by appeal or otherwise should be read to say a portion of an order remanding a case shall be reviewable by appeal or otherwise, solely with respect to the text of that. I know you have arguments outside the text, but with respect to the actual text, what's your best argument?
Sure, Your Honor. The first thing we have to keep in mind is that you have to look at the sentence as a whole, including the first clause, which is a general and absolute bar on appellate review remand orders. So then when we look at the second clause, we have to look at the words not in isolation, but as in relation to their neighbors. And there we see that an order is reviewable, but only if it is an order that in which the removal was pursuant to Section 1442 or 1443. Petitioners assert that pursuant to is merely a label in the removal notice, but we know that can't be right because, for example, in an earlier section in 1446, which is actually the procedure for removal of civil actions, the removing party the attorney has to file pursuant to Rule 11. And Rule 11 has both a procedural signature component and substantive. That is, that the grounds have to be done not for delay and with substantial basis in the evidence, et cetera. Now, the key point is that the issue isn't whether the order is reviewable, but what the scope of that review is. And both the structure of the sentence, that is, the tethering to 1442 and 1443, and this court's treatment of similar language in other statutes like 1257, the Criminal Appeals Act, and Section 1291, review of single orders is limited to certain issues within those orders, even though the language of the statute itself doesn't distinguish among those issues. So for all those reasons, the use of the word order and the use of the word reviewable have never meant to this court that necessarily means a reviewing court has to address every single issue raised within an order. To the contrary, this court has frequently disentangled issues and made clear in cases like Swint and Abney and Behrens, all of which petitioners ignore, that you cannot use an appealable issue as a ticket for multi-issue appeals that are not allowed.
Thank you, counsel. Justice Thomas?
Thank you, Mr. Chief Justice. Counsel, I don't want to belabor the point, but I think it's an important point. Could you give us, you mentioned some cases that support your point. Could you give us further details about those cases and why they support your point?
Sure, Your Honor. And let me point to one other structural thing in Section 1447 itself that supports this analysis. Section 1447C says that an order remanding the case may require payment of just costs and expenses incurred as a result of the removal. So it requires the award of fees to be part of the order. The circuits that have looked at this, and it's 12 of them, only the Federal Circuit has not, have held that the award of fees is reviewable even if the rest of the order falls within the bar of the general non-reviewability clause. As to your specific question about cases, in Swint, a case involving Section 1983 claims there was a single order denying motions for summary judgment. This court said that the portion of the order denying qualified immunity was reviewable, but not an order whether specific defendants were policymakers. That portion of the order was not reviewable. In Abney, there was a single order, and it was okay for the appellate court to review the order denying a motion to dismiss with respect to double jeopardy, but not with respect to the same order denying challenge to the sufficiency of an indictment. And in Behrens, a wrongful discharge case, Justice Scalia explained that a single order could be be reviewed with respect to the issue of denying qualified immunity, but not with respect to determinations of evidentiary sufficiency. And in our brief, we discussed the cases under the Criminal Appeals Act and as well as under Section 1257. You cannot allow a party that has a non-meritorious issue, as as petitioners have here, to use that issue as a hook to open up issues that this court and the statute have plainly barred.
Thank you.
Justice Breyer?
Good morning. I see the linguistic argument, which is tough for you, but I see the argument from that's order and the argument from Yamaha. Let's overcome those. I'm not focusing on those. I want to focus on a problem that occurred to me. It's in every legal system. It's important to have an appeal. It's unfair not to give people appeals. But if you give them appeals in the middle of the case too often, you will really muck up the system, take too long. And so we allow some things to go ahead even though there was no appeal, and it might be unfair and wrong because we don't want to muck up the system. That's what I see underlying this statute since 1887. You know? No appeal. But now they have an appeal on some things. So you're not going to waste a lot of time. It's in the Court of Appeals anyway. You'll waste some time if you let them have other things. But the big waste, the big time-consuming thing is getting the appeal in the first place. Now it's here. So we've undercut the main reason for not giving people an appeal. We've undercut it, not destroyed it. Now, if that's correct policy, then that's on the other side that you're trying to argue. So I want you to see what you think.
I don't think it is, Your Honor. These grounds for appeal, as this court explained in the Ruiz case, talking about why that provision was jurisdictional and limited to a single issue, diversity jurisdiction is a good example, Your Honor. You don't obtain diversity jurisdiction by having a colorable argument that there's diversity or jurisdiction. You either have it or you do not. The same is true for federal officer jurisdiction. It either exists or it does not, and if it does not, then the plain language of we think the plain language of the statute limits and tethers the appellate court's scope of review, and that's the end of the issue. The notion that there's an efficiency that requires a court is based on two assumptions, both of which are wrong by the petitioners. The first is that there's a link somehow between asserted grounds for removal. But the fact that a party has asserted federal officer jurisdiction, which it does not have, and which in this court it doesn't challenge, does not mean that it's entitled to bankruptcy jurisdiction or admiralty jurisdiction or federal enclave jurisdiction or any of the other jurisdictional assertions that have been made by the petitioners in this case. There's no link. There's no reason to open up the other issues. And second, just as a matter of statutory construction, you don't have to read the second clause narrowly to understand that it confines the broad language of the first language. How does it confine it? Well, it restricts it to sections 1442 and 1443. And 50 years.
The argument on policy is, look, the case is here anyway. Big deal. Let's decide the issues. They take a little bit, not a lot of time. That's the mouse, and the elephant is no longer there. The elephant takes a lot of time to appeal, so let's not give him any.
Your Honor, and this case is a good example of the reason that we should be concerned about this. We've been 3 years in limbo between the federal and state courts, and the record below, if you look at the only thing Your Honors have from the record is the notice of removal, but there were 43 exhibits comprising more than 1,100 pages that were part of that. And to foist on the courts of appeals records of that extent and issues, it does not take a lot of extrapolation to understand how that would burden the courts of appeals.
Justice Sotomayor?
Counsel, would you address the ratification points the SG spoke about the counters that he mentioned to why ratification doesn't assist you in this case.
Yes, Your Honor. Thank you. Two points. The first is that it's factually incorrect that the 9 circuits that addressed this issue prior to 2011 contain no analysis. They all found the language clear, the common sense reading of the statute clear, and many of them pointed that out in particular. But with respect to the body of case law, petitioners and the United States ignore, and I think it's significant, a couple of important cases from this court. The first is Helson from 2019, a unanimous opinion in which the court was confronted with a line of cases from the Federal Circuit involving interpretation of patent law. And the Federal Circuit, of course, was the only one with jurisdiction over these issues. The court relied on that line of cases out of the Federal Circuit and the fact that Congress reenacted not just the same language, but added only a new catch-all phrase. And as the court and the United States as amicus in that case said, that would be a very oblique way of attempting to overturn the settled body of law. The settled body of law comes from what a practitioner looking at 9 unanimous circuits over 50 years would think at the time, and that is that where there is a federal officer or civil rights assertion and other issues, the only issue that the Court of Appeals has jurisdiction to review are those issues. And that's what Congress ratified by reenacting the language and only adding 1442 or. There was also, and we cite to the House report, which points out that the reason for this addition was specifically to protect federal officers from removal as civil rights cases do, because otherwise there is no way to get the issue into the Court of Appeals. So Congress put its thumb on the scales for 2 issues, federal officer and civil rights, because there were important public policy reasons to protect those kinds of defendants against district court error. In all other cases, Congress has made clear, and the courts have consistently held, as has this court, that if it's a subject matter jurisdiction issue or another ground barred by 1447C, there is no right to appellate review, and it's jurisdictional, not just, as Justice Scalia said, it's not just hortatory.
Thank you, counsel.
Justice Kagan?
Mr. Scherer, on your gamesmanship point, why isn't a Bell v. Hood rule or even the possibility of sanctions sufficient to remove that as a concern?
Because the burden comes from that large gray area between frivolity and meritless, ultimately meritless. And that's where, as the 10th Circuit put it, no competent lawyer would, if the rule changes this way, every competent lawyer will look for a way to assert federal officer simply so that other grounds can be brought up on appeal. And again, the statistics from the 7th Circuit are actually ambiguous because, as the state and local governments associations amici point out, while in Liu Junhong, the 7th Circuit said that following our opinion, it would be frivolous to assert federal officer removal as a basis for removal in future cases. In fact, there have been future cases in others, albeit in other circuits, raising exactly the same issue. So yeah. I'm sorry,
go ahead.
I'm sorry.
I mean, you said every competent lawyer, Mr. Scherer, but 1442 and 1443 are pretty specific grounds for removal. It's not like everybody's going to have a plausible 1442 ground, is it?
Well, Your Honor, the assertion of federal officer jurisdiction in this case, which was rejected by now 4 circuits, including the 4th Circuit below, was really based on doctrines that have been soundly disapproved and rejected by this court, ranging from government regulation and supervision to a lack of connection between the conduct that's the basis of the tort, which is misrepresentation and a campaign of deception and denial, and any relationship to the government, much less any appropriate federal interest in promoting those kinds of lies and deceit. But we see them asserted continually, and again, as the same amicus, as well as the New York State amici point out that removal has become a tactic of defendants in a wide range of cases, including environmental regulation, opioids, subprime lending, and financial institutions, and others. And in every one of those instances, these are involved national industries, heavily regulated by the federal government, and you could have colorable assertions and a rule that broadly opened the gates to other issues, and appellate rights would not only result in longer delays, but would burden the records of the courts. These are not just our cases, Your Honor, but big cases involving large companies and important interests frequently bump up against federal interest, and the issue here is whether there's a federal officer connection, which there is not.
Thank you.
Justice Gorsuch?
Good morning, counsel. I'd like to return to the text where the Chief started us, and it seems to me that everyone would agree that the first clause of 1447's reference to an order remanding a case to the state court from which it's removed is not reviewable. That first portion, everybody agreed that's the whole order. It's not like a court can review some of it. And normally, the question is what happens to the term order as it appears in the second clause. And normally we read a statute that uses a single term to employ the same definition throughout. The government charges that that's one defect in your statutory interpretation. I didn't hear you address that concern in your discussion with the Chief, and I was hoping you might now.
Thank you, Justice Gorsuch. So 2 points. First of all, the first clause of subsection D has to relate to subsection C, which includes an order remanding the case may require payment of just costs and any actual expenses incurred as a result of the removal. And every circuit, 12 circuits have looked at that, and they have all concluded that regardless of whether the ground for the removal is reviewable under the first clause of subsection D, they can address that issue. And under petitioner's view, they could not unless it was a case involving 1442 or 1443. So that's the first point. The second point
put aside 1447C. There's a whole list of arguments. We could go down that rabbit hole. I'm really just focused on D at the moment.
Okay. So D is an exception clause and has to be read in light of the first clause, which is a general bar. And it says removed pursuant to section 1442 or 1443. Now, that cannot be procedural because 1442 and 1443 are exclusively substantive. They set forth the standards for federal officer and civil rights qualifications for removal, respectively. So pursuant to section 1442 or 1443 must mean something other than simply that the notice of removal referenced them. And this is why that language acts both as a tether, as a matter of common sense interpretation of the statute, focusing the Court of Appeals' attention on those issues and those issues alone, and as a substantive bar, because pursuant to, as this court has interpreted it in other contexts, and as the Constitution uses the phrase in pursuance to for legislation, means not just procedural compliance, but substantive compliance.
And what do you do about Yamaha? I understand that the question there was when, and it's which order is the question here, what part of it. So the questions are different, I get that, but I'm not sure I understand why that difference makes a difference, given the scope of our reasoning in Yamaha. Do you want to address that for me?
Yes, thank you, Your Honor. It is because the key point in both Yamaha and here is not the use of the term order, but answering the question, what is the scope of review on appeal? And in Yamaha, looking at the language of what the district court can certify as involving a controlling question of law, and looking at the appellate court's discretion to either accept the appeal, the interlocutory appeal at all, or move on to other issues within the scope of the order, the court said the scope of review under those conditions in that context made sense. But
Justice
here,
Kavanaugh? Oh, I'm sorry. Finish your answer, please.
Oh, thank you, Your Honor. I'll be brief. In 1447D, which is a jurisdictional statute, the language is limiting, not discretionary. It's mandatory, and it can only it should only be read. We submit to focus attention on the 1442 or 43 grounds.
Justice Kavanaugh.
Thank you, Chief Justice. Good afternoon, Mr. Chair.
Good afternoon.
Start with an atmospheric question. I know the Maryland state court system is very strong and has an excellent reputation. I know the Maryland federal judiciary similarly is filled with excellent judges. I asked Mr. Shamgam why he wanted to be in federal court. He gave me a legal answer. He didn't really go beyond that. You really want to be in state court. Why?
We don't believe federal court jurisdiction exists in the cases. There is no federal claim to assert here, Your Honor. The tort that is concerned, that we're concerned with, and the Fourth Circuit addressed this in detail in its opinion, as did Judge Hollander in the district court. It's on pages 21A and 22A of the circuit court's opinion in the record. Pointed out that the conduct complained of is fraud, deception, denial, and disinformation, and that those are traditional state foci and traditional state remedies.
I get that.
Which, frankly, at this point, there is no federal analog.
Right. Okay. So that's your legal answer. That's fine. Moving on to a different question. As Justice Gorsuch said, I think the text in isolation is a problem for you, and that means the text is a problem for you. You also, I think, have a problem with Yamaha, and it's never good to be on the wrong side of Justice Ginsburg's opinion, but particularly on a jurisdictional issue. And what she wrote for the court there is, as the text of Section 1292B indicates, appellate jurisdiction applies to the order certified to the Court of Appeals and is not tied to the particular question formulated by the district court. And that language, as you know well, is similar. What do we do with Yamaha? Justice Gorsuch was touching on this as well, but that sentence in particular seems problematic.
Well, I think you start with this court's interpretations of Section 1291, in which the court has said that despite virtually identical language about what is appealable from the district courts, that only certain issues within an order are appealable and or reviewable, and others are not. And the other two statutes that we discussed at length in our brief. And Yamaha's reference to order was in the context of a particular statute, setting aside congressional intent and purpose, which I think also cut in our favor here, but simply looking at the language of Section 1292B it is not similar in its common sense reading to the common sense reading of 1447D.
Okay, one last question,
again,
Mr. Chair,
sure.
Which is on the reenactment canon, which Justice Sotomayor and I have been asking about.
Sure.
Just looking at our cases, it looks like it's often used, to borrow a phrase in a different context from Justice Kagan, like icing on a cake already frosted when we use the doctrine. You cited Helson, and that's a good case for you to cite. I agree, but that was relying mostly on the fact that our precedent, we were sticking with our precedent. Then it did mention the reenactment, but Professor Eskridge, in his treatise, has pointed out that the presumed intent justification behind that doctrine is, in his words, unusually weak, end quote. And I just wonder how much work it can do here, given that it's really not clear. We don't have any indication that Congress actually, or members actually focused on this and intended in any way to ratify the interpretation. Can you respond to that?
Yes, Your Honor. First of all, in Helson, the point was there was not controlling authority from this case. I'm sorry, from this court, but rather there was from a circuit court, the federal court, the federal circuit. And second, in his treatise, Scalia and I'm spacing whether it's Garner or Warner.
It's Garner.
Garner, thank you. The issue is whether a practitioner at the time would view the issue as settled. And here, a practitioner in 2011 would look at the unanimous 50 years of precedent from 9 circuits that had all held that if the issue goes up to a court of appeals and it's among several, that only the 1442 or 43, actually to that point it was only 1443 ground, could be reviewed.
Justice
and would
Barrett?
conclude.
Counsel, I want to walk you through a procedural question that I have about your interpretation. So I want to talk about your pursuant to argument, in which you say that a case hasn't been removed pursuant to 1442 or 1443 unless it has been correctly removed pursuant to those cases. So in other words, in this case, because the officer removal ground was flawed, we couldn't say that this case had been removed pursuant to the officer removal ground. Has any court of appeals ever adopted that argument?
For 1442 and 43? As it turns
you're
out,
reading you're reading a 1447D, which you say that pursuant to, you lean on pursuant to as one of the reasons to construe the statute your way.
Correct. And the answer is yes. In fact, it was the Fourth Circuit in a 1969 opinion called House v. Dorsey, 408 F. 2nd, 1008. It was a 1443 removal solely. The Court of Appeals looked at it and held that the removing party did not qualify under 1443 and dismissed for lack of jurisdiction.
Well, the court didn't do that here, right? Because, I mean, if you're right, it seems like on appeal, if the Fourth Circuit in this case concluded, as it did, that the remand order was proper, that it had not been properly removed under the federal officer removal statute, that it should have dismissed for lack of jurisdiction, not affirm the remand order, correct?
Yeah, correct, Your Honor. The general practice, though, in fact, the universal practice in the courts that have applied a common sense language interpretation to the statute has been to dismiss the other grounds asserted for lack of jurisdiction and then either affirm or reverse on the merits of this particular.
But, counsel, that's inconsistent with your reading of the statute, because if the court doesn't have jurisdiction unless the case has been properly removed pursuant to, say, the federal officer removal statute, there's no jurisdiction. It can't affirm. It would have to dismiss even on that ground. So if courts were implicitly seeing it your way, they wouldn't procedurally be disposing of these cases this way.
So there are two things. One is we offer two different ways of reaching the same result. One is under a common sense language reading of the statute in which the words pursuant to qualify the exception and tether the appellate court's review to those issues, but it's not necessarily, as Your Honor points out, it's not necessarily a jurisdictional analysis. It just means that the appeal has to be limited and focused on those grounds. The other reading is the jurisdictional analysis, which we think flows from the use of terms that this court has consistently held have substantive jurisdictional meanings, for instance, in Helmerich and in Ruiz.
So, counsel, I just want to ask a clarifying question. When you say the jurisdictional analysis, is that the analysis that I just asked you about? Is that what you're calling your jurisdictional analysis of pursuant to?
Yes, Your Honor. Pursuant to establishes a jurisdictional threshold, and that a case must substantively comply with the requirements of 1442 in order for the case to have been removed pursuant to that provision.
Well, counsel, let me turn you back to your other pursuant to argument, which, as I understand it, kind of implicitly means pursuant exclusively to. Does that make sense? Because then someone who had a basis for removing under, say, the civil rights removal statute would be discouraged from including any other grounds.
No, Your Honor. No, Your Honor. The point is that on appeal, having been remanded, the error that can be corrected by the Court of Appeals is limited to the specified ground, and that's what the common sense reading is. Nothing is allowed except it is allowed to look at orders remanding pursuant to specific provisions.
A minute to wrap up, Mr. Scheer.
Yes, thank you, Your Honor. The best common sense reading, following up on this colloquy, of the exception clause is that it creates a limited exception to 1447D's general bar on appellate review for federal officer and civil rights grounds, and only for those grounds. Petitioner's reading would create an exception that swallows that rule, an exception that would apply to one group and one group alone, defendants who make meritless claims to removal on either of them. The text does not compel this reading, and it is implausible to think that is what Congress intended. The interpretation also runs contrary to the principles and purposes that animate Section 1447D. Consistent with the nearly unanimous view of the lower courts, including the four circuit courts to decide this issue in the last year, and consistent with the view ratified by Congress in 2011, this court should affirm.
Thank you, counsel. Mr. Shanmugam, rebuttal.
Thank you, Mr. Chief Justice. There is one fundamental problem with respondents' argument today. It finds no home in the actual language of Section 1447D. There's simply no way, as a matter of ordinary English, to construe order to mean merely a portion of an order. In Yamaha, Justice Ginsburg, writing for a unanimous court, relied on that plain meaning to reach the same conclusion. And respondents' interpretation would have the added consequence of giving the phrase order remanding a case different meanings in different clauses of the very same statutory sentence. Respondents' only colorable textual argument here is its ratification argument. But Justice Kavanaugh, this is anything but a classic case for ratification, especially in the absence of any relevant legislative history. As Justice Scalia explained in his opinion for the court in Alexander versus Sandoval, the relevant inquiry is whether one can, quote, assert with any degree of assurance that congressional failure to act represents affirmative congressional approval of the court's statutory interpretation. Here, there is simply no reason to believe that Congress was preferring the unreasoned decisions of some courts of appeals construing this statute over the reasoned decisions of this court construing materially identical ones, particularly given the technical nature of the 2011 amendment. Congress could well have concluded that it wanted plenary review in these cases and that the value of correcting erroneous remands in these specific contexts outweighed the cost of any incremental delay. Justice Thomas, you expressed concern that this could lead to the smuggling in of additional issues on appeal. Of course, under Section 1291, plenary review is the default, not the exception in our appellate system. But there's no reason to believe that there are going to be a lot of these cases. As the DRI amicus brief notes, in the 5 years since the Seventh Circuit adopted our interpretation, there have only been 6 notices of removal citing either of these statutes, and only 3 appeals in those cases. And again, sanctions and fees are available to deter any abuse. Indeed, the very provisions at issue here specifically state that notices of removal are subject to the requirements of Rule 11. And finally, delay is not a significant concern here. Justice Sotomayor, the reason there has been delay in this case has not been because of the other grounds for removal, which, because of its erroneously narrow view of its own jurisdiction, the Court of Appeals, after all, did not reach. Our rule would enable courts of appeals to resolve these appeals more efficiently where a court concludes that there is an easier ground for removal than the often fact-intensive federal officer ground. And there would be delay only in a case in which a federal court stays the state court proceedings on remand, which would occur only when the court determines that a defendant is likely to succeed on its appeal. There's therefore no good policy reason to override the plain text of Section 1447D, and because there is plainly federal jurisdiction over these claims, this court should therefore reverse the Court of Appeals judgment. Thank you.
Thank you, counsel. The case is submitted.
The Honorable Court is now adjourned until Monday, the 22nd of February at 10 o'clock.